will now hand over to Mickey Brady for his opening remarks. Thank you.
Thank you, Janice. I was a member of the Health Committee in the last mandate, and I'm a member of the Health Committee in this mandate. I was also in DSD Committee last mandate and this mandate. Two very busy and interesting committees, I have to say. So I welcome this opportunity to open today's seminar on supported and substitute decision making under mental capacity legislation. The research is of particular interest to the Health Committee, as we have recently started to take evidence that will facilitate the consideration of the forthcoming Mental Capacity, Health, Welfare and Finance Bill proposed by the Department of Health, Social Services and Public Safety. The Mental Capacity Bill will be rather unique in comparison to the rest of Britain in that it will encompass both mental capacity and mental health into one piece of legislation. A single bill was one of the key recommendations that came out of the Bamford Review. Bamford also advocated that the new legislation should be based on 4 principles, namely autonomy, justice, benefit and least harm. It is intended that the Mental Capacity Bill will apply to decisions covering all aspects of an individual's life, including their care, welfare, treatment and financial affairs. Amongst the proposals is a statutory presumption of mental capacity. However, when a person is considered to lack capacity, substitute decision-making provisions and safeguards of the legislation will come into operation. We need to ensure that the legislation supports and protects people who may be unable to make decisions for themselves, as these are some of the most vulnerable people in our society. And this leads me on to introduce Gavin Davidson from Queen's School of Sociology, Social Policy and Social Work. We're delighted that Gavin can join us today to present his review of the international evidence and legislative supported and substitute decision-making framework. Gramaga.
So thanks very much, Mickey and Janice. It's great to get the opportunity to present this work and yet have a comprehensive legal or policy framework to provide supported and/or substitute decision making. So that's the key issue, and that needs to be in place for many reasons. There are people who, without support, would be assessed as incapable of making certain decisions, so it requires substitute decision maker, but with the appropriate support are capable of making those decisions. So if we don't have that support in place, it means those people's rights are infringed, their ability to make decisions about their own lives is restricted. So supported decision making refers to part of a continuum decision making from autonomous decision making right the way through to substitute decision making. Law and policy, I think it's fair to say, have tend to focus on either end of the spectrum, on completely autonomous decision making, where you're free to choose, obviously, and aren't offered any support with that, and substitute decision making, where someone else makes the decision for you. I think we have a great opportunity with the Mental Capacity Bill to look at both a comprehensive framework for substitute decision making, but also supported decision making. So just a few definitions to clarify the terms mental capacity. I think the clearest way to explain it is just thinking about it in this context as your ability to make your own decisions. Supported decision making refers to a framework within which people, in this quotation at least with a disability, but it can be for a whole range of reasons across dementias, probably the most common reason, and mental health problems, learning or intellectual disabilities and brain injuries would be the other main reasons. So a framework within which people whose decision-making ability is impaired can be assisted to make valid decisions. So supported decision-making involves providing a person with the support they need to make their own decision. It's often contrasted with substitute decision-making, as I've said, where decisions are made on people's behalf. So, as I've mentioned, substitute decision-making then refers to the legal framework which we're currently developing under the Capacity Bill to enable decisions to be made for people who lack the capacity to make them. It includes a whole range of provisions internationally, such as powers of attorney, court-appointed deputies, guardianship, boards of court, and compulsory intervention under mental health law. So the current Northern Ireland context for supported and substitute decision-making is that there are some aspects of supported decision-making addressed through the Department's guidance on consent, and in general through good practice. In health and social services, if a person's decision-making capacity is impaired, the people who are working with that person should be involving them in all aspects of their care and decision-making processes about that, and facilitating and supporting them to do that. But we don't have a formal framework for people to do that. The Mental Health Northern Ireland Order obviously provides for substitute decision-making, but that's on the basis of people having some form of mental disorder and presenting a sufficiently high level of risk. The Office of Care and Protection provides the ability for substitute decision-making to be made for financial matters. And when a person is capable, it's possible for them to appoint an attorney to make decisions on their behalf if at some point in the future they no longer have the capacity to make those decisions. You can currently make an advance decision under common law, which is an advance refusal of some specific form of medical intervention. But the huge gap in our current framework is that if there is a dispute around a health and welfare decision for a person whose decision-making capacity is impaired, that has to be resolved in the High Court. So I would argue currently the vast majority of those decisions are made without any form of legal framework or legal protection and safeguards. Okay, so there are a number of arguments for the need for this comprehensive framework of both substitute and support decision-making, rights-based effectiveness and pragmatic arguments. The United Nations Convention on the Rights of Persons with Disabilities from 2006 and ratified by the UK in 2009 requires us to take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity. So there's a clear requirement for us to be doing this in terms of human rights standards. The central sort of rights-based idea is respecting the principle of autonomy. So the idea that no person should have another person appointed to make a decision on their behalf if it could be made, if the person could make the decision themselves with assistance and support. So it's a very clear and reasonable principle, I think. In terms of effectiveness, there are a number of arguments suggesting why it would be beneficial to have a support decision-making framework in place. Chartres and Braley identify three broad benefits. First is that it supports personal autonomy, so your ability to make decisions, and a person's authority and control over your own life. It provides a clear structure for individuals and families negotiating and making decisions and plans. So the idea that it may resolve some of the disputes that can arise within families around decision-making processes. And the third reason they suggest is that it provides a more comprehensive means of ensuring people's legal and personal capacity to make decisions is promoted and respected, as we're required to do. In terms of benefits for the individual, they suggest for people who are supported to make their own decisions, it can increase their sense of control and personal empowerment and self-determination, self-esteem. It can also facilitate them to develop their decision-making skills. So your ability to make decisions may well vary over time. If you're supported to make decisions, it may obviously increase your ability to make those decisions in the future. And it can also facilitate the development of people's support networks, as you're often part of an intervention to support decision can often involve using a person's support network to help them think about what the options are. In terms of benefits for everybody, it can include those include enhanced protection against institutionalisation and abuse. I think we've clear examples, certainly from mental health services, of the difficulties arise when people aren't involved in making decisions about their own care, or where they don't have the opportunity to make those decisions. And it will also facilitate people who have traditionally been socially excluded to varying levels to be more included in society, again to the benefits of us all, and essentially it will enable better decisions to be made. There are also, these aren't the sort of most important arguments, but I think there are also a number of pragmatic arguments about why it's a good idea to enable people to make decisions for themselves. There's a body of research around procedural justice in mental health services, which suggests if you're assessing someone for some form of compulsory intervention, if you involve them in that process and listen to them and they feel heard, they're much less likely to feel coerced, and they're much more likely to cooperate with whatever the care and treatment proposed is, even if they disagree with the decision. And it does seem to make intuitive sense that if a person has received the support necessary to make their own decision, they may be more willing to engage and benefit with whatever care and treatment is proposed. Okay. So the review of the evidence, the methodology for this was what's in research methodology called a rapid evidence assessment. It was completed using both database and grey literature searches. The findings were mainly from North America, the UK and Australasia. So this type of methodology, it provides a good overview, I would argue, a synthesis of the evidence. It's not a systematic review, so it's not looking at everything that's available on each area, but it does provide a good overview, and I think it's more appropriate with a very broad subject like this. So the process, just very briefly, involves developing search strategies, using those to go through the available databases, then identifying what are the most sort of relevant articles usually to include. Okay, so there are a number of sort of clear findings from the review. The first, as we've talked about, is there are a range of strategies between substitute decision making and autonomous decision making where people can be supported to make their own decisions. So there are a range of ways of doing that. At the most basic level, there's clear research evidence which suggests providing very clear information and simplifying decision-making processes facilitates people to make their own decisions. That's certainly a consideration for the bill about how the process of a person his capacity being assessed, how simple that is and easy that is for them to understand what's happening and to engage with that process is a very important consideration for practice, I think. Person-centred planning, which is an approach which is developed mainly in learning or intellectual disability services, is also supported. Within person-centred planning, there are a whole range of very creative ways of engaging with people, often using sort of mainly visual means. But those means can be used to develop plans about a person's life. Independent advocacy, representation and supportive networks can also be effective for support decision making and so preventing the need for substitute decision making. So there are a range of approaches within the evidence which are supported as being effective. And another sort of main theme within the literature is that the full range of those approaches is needed because what is most effective will vary across people and will also vary across time and across decisions within each person. Okay. There are also a number of very helpful sources already available to us from other jurisdictions in terms of supported decision making. Under the Mental Capacity Act 2005 Code of Practice in England, there's specific guidance on how people should be helped to make their own decisions. It's not comprehensive, but it at least suggests you need to provide relevant and accessible information that needs to be communicated in an appropriate way, and you have to work with the person in a way which makes them feel at ease and support them where possible. In Scotland, there's similar guidance under the Adults with Incapacity Scotland Act, 2000, which is from 2000, although the guide's from 2008, and it refers specifically about the communication and assessment processes when you're trying to determine whether a person has the capacity to make a specific decision. The wording they use in both these jurisdictions is that all practical steps should be taken to ensure that the person is supported to make their own decision. Okay. Another finding from the research literature is that it does appear very difficult to ensure that good practice in supported decision making is consistently provided across all settings if it's not clearly required. So in jurisdictions where you don't have a legal requirement and a policy requirement that people should be doing this consistently, it tends to be restricted to just pockets of good practice where you have very motivated people or very motivated organisations trying to get these initiatives in place. And even in jurisdictions where there is a clear commitment in law and or in practice guidance, inconsistencies in practice do arise. In terms of the implications of that, I would argue that supported decision-making, rather, along with the associated provision of advanced care planning and independent advocacy, which are part of that framework, I think, should therefore be included within the proposed mental capacity bill and its associated code of practice. My understanding from the process of it being drafted is that there will be a similar commitment around the idea that all practicable steps should be taken to support a person and to ensure they can make their own decision, and then that will be further developed in the code of practice. There's a very strong theme in the literature about the need for staff training due to concerns about levels of knowledge, inconsistent practice and the lack of involvement of service users. And there's also, more encouragingly, clear evidence of how effective training is for getting people to think in this way and approaching working with people in this way. So in terms of looked at a number of different laws, but the most interesting ones, I think, for informing the current development of the bill, the first is the Healthcare and Consent Act in Ontario. So within that, this just does refer to health decisions, but mental capacity is the sole gateway criterion across all interventions, settings, and even you'll be interested to know, you're probably already aware, across all ages. I have some reservations about the application of a capacity-based framework across all ages, but this is certainly an example of it working in practice. The other sort of main law I looked at in practice was in Saskatchewan. It's their Mental Health Services Act from 1984. And it has, as well as the standard and what we currently have in place, mental disorder and risk, it has another criterion which, to allow compulsory intervention, the person's decision-making capacity must be impaired. So we currently don't have that third criterion, but they have it there and it's working well. I suppose part of the reason for including this was these are two examples of capacity-based legal frameworks that have been in place for many years and are working well. What we're proposing in Northern Ireland is more progressive than this because it draws all areas of decision-making under one legal framework, and these are specific to health. But nonetheless, they also have sort of different laws which apply to the different areas. So it's more fragmented, but together it would represent a similar approach to what we're proposing for Northern Ireland. So the main concern identified by the practitioners I've shadowed in Canada was not about having capacity as the sole gateway criterion for compulsory intervention, but it was about the assessment of capacity and where the point was where you said this person is not capable of making this decision, and about making that assessment of capacity consistent across practitioners and across areas of practice. As I've said, the application of the Healthcare and Consent Act to children across settings does suggest that including the criminal justice system, which is currently being considered by the Justice Department in their work on the bill, and the current debate we're having about whether the bill could apply to children, but both are certainly possible. I mean, that's the application in Ontario. As I've said, there are issues about that, and I'm sure we'll sort of discuss those. If you're interested in the findings of that, my full report from that trip is on the Memorial Trust website. So, in conclusion, I think that the Mental Capacity Bill does have the potential to provide a world-leading, non-discriminatory and unified framework for substitute decision-making. I think it's an extremely exciting development for Northern Ireland, and there are many jurisdictions around the world who are very interested in what's happening here and supportive of it. The focus in the development of the bill has been on the arrangements for substitute decision-making, which is reasonable. I think that is the appropriate focus of the bill. But I think that the process of developing the bill offers the opportunity, perhaps there's a clear commitment in the bill and guidance in the Code of Practice to develop what could also be a world-leading framework for supported decision-making. And as part of that, a really sort of clear theme within the literature is the need for sort of the appropriate training and workforce planning to enable that to happen. Even if it's in policy and law, the research findings are clear that it needs to be, people need to be appropriately trained and ready for it.